Gary DeWall here, and this is Bridging the Week for December 8th to 12th, and today is December 15, 2014. Good morning. It was a busy and diverse week of developments in the financial services industry last week, with no one common theme, as many aspects were touched by regulators and courts worldwide. In addition, both the chairs of the Commodity Futures Trading Commission and the Securities and Exchange Commission gave some further insights into their priorities, while the European Commission formally delayed implementation of a potentially punitive capital hit for European banks exposed to U.S. clearinghouses. There was a tremendous amount going on last week, so let's get started. The Bank of New York Mellon was absolved of having engaged in quote-unquote egregious misconduct in connection with its relationship with Sentinel Management Group by a United States federal court in Chicago. Sentinel was an investment management firm registered with the Commodity Futures Trading Commission as a Futures Commission merchant that claimed it specialized in short-term cash management for hedge funds, individuals, financial institutions, and FCMs. The firm filed for bankruptcy during August 2007 after it unlawfully commingled client securities into its house account and used client collateral to obtain a line of credit. Eric Bloom, Sentinel's former chief executive officer, was convicted earlier this year of defrauding Sentinel's customers and awaits sentencing. In its current decision, the court held that Bank of New York's conduct was not sufficiently wrongful to defeat its lien against Sentinel, and that its loan against collateral was made in good faith and cannot be avoided. In holding for the Bank of New York, the court noted that the National Futures Association had audited Sentinel annually through 2006, and that McGladrey and Pullen LLP, its predecessor firm, had routinely issued unqualified audit opinions regarding Sentinel's statement of financial position. Relying on these reviews and the lack of other notice, Bank of New York was justified in thinking nothing was askew, claimed the court. The conviction of two individuals, Todd Newman and Anthony Chiasson, for insider trading under United States securities law, was set aside by a federal appeals court in New York last week. The court claimed that, in its prosecution of the defendants, the U.S. government failed to demonstrate that the initial insiders, from whom defendants' liability ultimately derived, received sufficient personal benefit to establish their, let alone defendants', security law liability. Moreover, said the court, the U.S. government failed to provide any evidence that the defendants knew, quote, they were trading on information obtained from insiders in violation of those insiders' fiduciary duties, end quote. Previously, Mr. Newman, a former portfolio manager at Diamondback Capital Management, and Mr. Chiasson, a former portfolio manager at Level Global Investors, were charged and convicted of trading in securities based on illegally obtained insider information, initially provided by employees at publicly traded technology companies, subsequently shared with analysts at hedge funds and investment firms, and ultimately shared with the defendants. The alleged insider information related to earnings announcements of Dell Inc. and NVIDIA Corporation prior to the public release of such information in 2008. The European Commission formally delayed the implementation of punitive capital requirements for European Union banking groups that had exposure to clearinghouses, or so-called CCPs, that were not determined to be so-called qualifying CCPs by the EC. Under European requirements, CCPs are considered qualifying if they are quote-unquote authorized for those established in the EU, or quote-unquote recognized for those established outside the EU. Only CCPs established in jurisdictions whose regulation of CCPs has been determined to be equivalent to that of the EC can be recognized by the EC. The oversight of clearinghouses by the Commodity Futures Trading Commission has not yet been determined to be equivalent by the EC. The transitional period before implementation of the new capital requirements will now expire on June 15, 2015. Mary Jo White, chair of the Securities and Exchange Commission, discussed her priorities regarding the SEC's oversight of the registered asset management industry during comments delivered before a conference sponsored by the New York Times at the newly opened One World Trade Center Tower in New York City last week. These priorities include addressing regulated funds, portfolio composition, and operational risks. According to Ms. White, portfolio composition risk derives from the makeup of a fund's investments and, quote, the impact that mix, including the interaction of particular financial instruments, can have on a fund, end of quote. The liquidity and leverage of a fund's holdings are part of this risk, said Ms. White. Operational risks come about from, quote, inadequate or failed internal processes and systems, end of quote, she said. Ms. White said the SEC must enhance the, quote, data and other information, end of quote, it requires to assess these risks, ensure that registered funds augment, quote, their fund level controls, end of quote, so they may better assess and address portfolio composition risks, and require firms to have plans for dealing with their clients' assets when, quote unquote, circumstances warrant. Meanwhile, in testimony before the United States Committee on Agriculture, Nutrition, and Forestry, Timothy Massad, chairman of the Commodity Futures Trading Commission, suggested that going forward in enforcement actions, the CFTC would, quote, seek to hold not just firms but also individuals accountable, end of quote. In his testimony, Mr. Massad also laid out his agenda for the CFTC going forward. Among his priorities are continuing to fine-tune rules to ensure they work for commercial end users, finalizing rules related to margin for uncleared swaps, swap dealer capital, and position limits, working with international regulators to harmonize approaches for cross-border issues, improving data reporting, and considering what, quote, additional measures, if any, might be necessary to address automated trading, end of quote. Mr. Massad did not propose any specific timeframes to implement his priorities. And finally, the operator of trading venues for securities that accepted payments for transactions in bitcoins and litecoins, so-called virtual currencies, settled charges brought by the Securities and Exchange Commission that the venues did not have required registration as an exchange. According to the SEC, Ethan Burnside and BTC Trading Corp., his wholly owned company, had established LTC-Global Stock Exchange and BTC Virtual Stock Exchange and conducted business through these entities as virtual currency denominated securities exchanges from August 2012 through October 2013. The exchanges were established according to the SEC to permit, quote, users to experiment with virtual currency investing by purchasing stock in virtual currency and or start a virtual currency company and issue stock to raise funds for that company, end of quote. Mr. Burnside also settled charges that he offered to buy and sell two virtual currency companies he owned and operated, and that BTC and he acted as a broker-dealer without registration. In connection with these matters, Mr. Burnside and BTC agreed to a cease and desist order and to disgorge profits of US $55,000 and prejudgment interest. Well, that's it for this week's Bridging the Week. As always, there's more information in each article, and more articles, in fact, this week, many more articles, on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWall. For those celebrating, have a happy Hanukkah, and for everyone, have a great week. Ciao!